Hello everybody and welcome to History Bite number 244, dated May 4th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled, A Lecture on Justice William J. Brennan Jr. For those who do not know, Justice William J. Brennan Jr. served as a member of the Supreme Court of the United States, an Associate Justice to be specific, from October 1956 until July 1991. Over nearly 34 years on our nation's highest court, Justice Brennan wrote some 1,360 opinions which touched on virtually every area of the law conceivable, affecting the lives of almost every single American in some form. He has been widely regarded as the most influential justice, arguably, in the court's history. As a member of the court's liberal wing throughout virtually his entire time on the bench, Justice Brennan possessed a unique empathy and rare comprehension of circumstances that translated into a legal theory in his opinions. For sure, Justice Brennan's ability to empathize with the individual and recognize the individual human dignity of all people certainly placed him in a unique category that most members of the Supreme Court could not hope to fall into. Justice Brennan's time on the court is best remembered, as being that of a judicial legend, a crusader, an armed knight who took up the cause for the persecuted, the discriminated against, the poor man, the marginalized, the weak, the stepped on, the trampled upon. You get the gist of it. Justice Brennan looked out for those in society who could be viewed as outcasts, and his empathy was genuine. This wasn't just for show, as he had nothing to gain from it for all intents and purposes. As a matter of fact, it tended to gain him more ridicule and chastising than anything, And Justice Brennan's empathy that translated into his jurisprudence could arguably be the result of his upbringing and life circumstances before and while on the court. So during this lecture, we will, discuss Justice Brennan's background before he arrived at the court, his time on the court, his jurisprudence per se, as well as his personal views and personal life. You'll learn probably a lot of things about the justice that you may not have previously known. All right, so let's get started. All right. William Joseph Brennan Jr. was born in Newark, New Jersey, April 25th, 1906, to first-generation Irish immigrants. All right, he was the second of 8 children, and he grew up under modest circumstances. They certainly were not rich. The Brennans, however, were able to provide for their children. All right. Even at a young age, he displayed a great deal of intellect, which led him to the Wharton School of Pennsylvania, graduating in 1928, and to Harvard Law School, graduating from there almost at the top of his class in 1931. One of his professors was future U.S. Supreme Court Justice Felix Frankfurter, who often, told his students to think for themselves. Brennan and Frankfurter would serve together on the court, for the record, some years later, between 1956 and 62. And he remembered that he told his students to think for themselves, but he remarked that Brennan goes too far. More about that later on. While at Harvard, Brennan excelled in his classes, but didn't exactly display any characteristics per se that would suggest that one day he'd be on the Supreme Court. Lots of students do well, but that doesn't necessarily mean they'll be on the Supreme Court one day. But nonetheless, I'll also add that the future justice never took any constitutional law courses while at Harvard. And he was also a member of the Harvard Legal Aid Bureau. All right. So when he graduated from Harvard Law in 1931, he returned to New Jersey, was admitted to the bar, and began practicing for several years as a labor lawyer. All right. During World War II, he was commissioned as a colonel, and once the war was over, he returned to the practice of labor law. In 1949, after, establishing himself and distinguishing himself in many ways, he was appointed by Governor Al Driscoll to the Superior Court of New Jersey, making it his first judicial appointment. At the time, he was 43 years old. He would serve as a standard trial judge in New Jersey before 18 months later being appointed to the appellate division of the Superior Court, which, of course, is the branch of the New Jersey State Judiciary that handles appeals from the Superior Courts immediately below the State Supreme Court. All right. While serving in these capacities, Brennan distinguished himself as a champion for, the alleviation of crowded court dockets. And, that definitely gained him the attention of the Chief Justice of New Jersey, Arthur Vanderbilt, who recommended to Governor Driscoll to appoint Brennan to the Supreme Court itself. And that is exactly what happened in 1951. All right. Brennan would be appointed as an Associate Justice of the Supreme Court of New Jersey. During his time on the Supreme Court of New Jersey, as he had done at the trial level, he, distinguished and established a record of being a fair judicial moderate, not leaning heavily either in the left or the right wing in his decisions. His primary causes were, the alleviation of crowded dockets, congested dockets rather, and fair and equal justice toward all individuals. So, nothing about him at this point still would suggest that he was headed for the Supreme Court. Arguably, there were lots of attorneys and judges in America at the time who displayed these qualities. It would not be until 1956 that due to the illness of Chief Justice Arthur Vanderbilt, that Brennan would finally display what could be regarded as his interview for the Supreme Court. Chief Justice Vanderbilt was scheduled to deliver a speech in Washington on the subject of congested court dockets, and he couldn't do that due to illness, so he asked Brennan to stand in his place, and Justice Brennan happily obliged. Brennan's speech, at least according to U.S. Attorney General Herbert Brownell, reflected the views of conservatism, law and order, and compassion, all of things that, would make an ideal Supreme Court justice. So he recommended Brennan to President Eisenhower as a potential Supreme Court justice. All right. In October of 1956, a Supreme Court vacancy was available, due to the retirement of Justice Sherman Minton. Eisenhower, was, interestingly enough, looking for somebody just like Brennan. He was looking for a Roman Catholic. He was looking for a Democrat, and he was looking for someone from the Northeast. All of which were groups that Eisenhower was trying to land in the 1956 presidential election. All right, so yes, this is an election year vacancy. All right, and Brennan fit the bill perfectly. To add to his desirability, he was also a state judge, something the Supreme Court had not had since Benjamin Nathan Cardozo was appointed about 2 decades earlier from that point. So Eisenhower would ultimately, issue New Jersey Supreme Court Justice William J. Brennan Jr. A recess appointment to the Supreme Court in October of 1956. According to accounts, Brennan had no idea that he was even being considered for the court by President Eisenhower. He didn't quite, catch on to it from Attorney General Herbert Brownell, all right, who, had to more or less tell him, dude, President Eisenhower is considering you for the Supreme Court. So Brennan was taken, by shock, shocked considerably by this. So, as anyone would be, he certainly didn't think he was Supreme Court material, all right? Brennan was a very modest guy, and, that modest mentality would serve him well on the court in the upcoming years, all right? So, having been issued a recess appointment to the Supreme Court in October of 1956, his tenure began on that great body, all right? When the Senate reconvened in January of 1957, President Eisenhower formally nominated him to the seat, had to make it official according to the Constitution. And, there wasn't a significant amount of opposition to the nomination of Justice William J. Brennan Jr., except from two groups, one of which opposed him because he was Catholic, all right? And they thought he would take greater direction from the Pope versus the Constitution, which is totally ludicrous, by the way. And another group led by Senator Joseph McCarthy, who thought Brennan was much too sympathetic to communism, all right? And ultimately, these groups failed to derail Brennan's confirmation, and he would be confirmed on March 14th, 1957, with only a single dissenting vote from none other than Senator Joseph McCarthy, okay, of Wisconsin. All right, so William J. Brennan Jr. thus was confirmed to a lifetime seat on the Supreme Court of the United States, all right, which takes us to, his jurisprudence and years on the court. Now, as I stated earlier, Justice William J. Brennan Jr. served on the Supreme Court of the United States from October 1956 until his retirement in July of 1990, okay? And during those 34 years on the court, his impact and influence fluctuated, being very high at first to, substantially lower in later years due to the addition of much more conservative members of the court. Now, William J. Brennan Jr.'s jurisprudence, okay, was beyond question that of a profoundly progressive liberal justice, again, taking on the causes of the downtrodden, the discriminated against, the persecuted, and he certainly did not view the way minorities had been treated as anything worth talking about, but rather that something needed to be done about it, okay? So Warren's first period on the court, Brennan's first period on the court was under that of Chief Justice Earl Warren from 1956 until 1969 when Warren retired. It was during the Warren court years that Justice Brennan's star shined its brightest, okay? During his time on the Warren court, he was an exceptionally influential member of that body, okay? And he had a remarkable influence upon Chief Justice Earl Warren himself. Warren and Brennan were friends both on and off the bench, and Warren personally was not as intellectually gifted as Brennan, and thus Brennan often provided much of the intellectual force behind a substantial amount of Warren's opinions, something that's often overlooked, okay? Indeed, Warren conferred with Justice Brennan so much that Brennan was often regarded as the vice chief or deputy prime minister by other justices. Warren and Brennan would meet with each other first before the court's general conferences, where they meet to decide the outcomes of the cases, and as some would say, plan their strategy, all right? Although some of those accounts are disputed as to, whether or not these two were plotting and, but 'tis no matter. In any case, Warren and Brennan certainly were on the same page about most of the issues of the day. The one rare exception being the constitutional protection of obscenity or pornographic material. All right. So when Justice Brennan was a member of the Warren Court, like I said, he had the most influence that he would ever have during his time on the Supreme Court. Right. He was a member of a solid liberal bloc, which included himself, Chief Justice Earl Warren, Justices Hugo Black and William Douglas, as well as Arthur Goldberg. And that majority remained intact throughout the 1960s, with Goldberg being replaced with Abe Fortas, and generally more conservative Justice Tom Clark being replaced by Thurgood Marshall in 1967. Thurgood Marshall would be taken under Brennan's wing once he got on the court, and the two became like glue, tight like glue. They became best friends and, voted together almost 95% of the time. They formed one of the longest lasting voting blocs in the court's history. Brennan and Marshall's opposition to capital punishment and spearheading of civil rights, affirmative action and integration, and just general civil justice, again, cannot be overstated. These two were, a formidable force in the early days. But that influence began to wane, like I said, with the end of the Warren Court and the addition of more conservative justices in the 1970s and 1980s. Okay, so some of the more famous Brennan opinions that came about during that period were Roth versus U.S., Cooper versus Aaron, Baker versus Carr, Malloy versus Hogan, New York Times versus Sullivan, Memoirs versus Massachusetts, and Warren certainly had, Brennan's influence in his opinions, like I mentioned earlier. Examples include, but are not hardly limited to, Miranda versus Arizona, 1966, Terry versus Ohio, 1968, and United States versus O'Brien in 1968. Warren was the author of these opinions, but Brennan's influence upon their ultimate structure and outcome is profound. All right, so that's the first period of Justice Brennan's time on the court, the Warren Court. Second period of his time on the court was under the Burger Court from 1969 to 86. It was during this period where the court was led by his old adversary, Chief Justice Warren Burger, who had previously been a judge on the D.C. Circuit and had verbally clashed with Brennan in the past. It was during this time that Brennan's influence began to wane, all right, with the addition of more conservative justices, at least at the time of their appointment. Chief Justice Burger himself, Justices Harry Blackmun, William Rehnquist, and Lewis Powell, all right. Burger certainly took the court to the right, all right, as much as he could, but not as much as people thought he would ultimately, okay? And, Brennan's solid majority was gone, all right? So at that point, for much of the early 1970s, it just included himself, Justice Douglas, Justice Marshall, Justice occasionally with the Nixon appointees, depending on the issue, Justice Powell and Blackmun, too, from time to time. His influence over the Nixon appointees, though, was limited. And like I said, it all depended on the issue at hand. When it came to the issue that came to define Brennan as a justice up to that point, the obscenity matter, he was unable to pull them into his orbit, okay? And in two notable cases, Miller versus California and Paris Adult Salon, both in 1973, the conservative majority on the court at that point certainly took the burden of proof off of prosecutors to prove that material was obscene, okay? And, it became up to the defendant to prove essentially that it was not obscene and had some sort of literary, artistic, political, scientific value known as the lapse test, okay? So as time went on, Brennan, the bond between Brennan and Marshall grew as they were the solid voices protecting civil rights and civil liberties, okay? And occasionally, like I said, they would be joined by Justices Blackmun, Powell, and of course Douglas while he was still on the court. You know, and with Douglas's retirement in 75, Brennan became the leader of the court's liberal wing. Okay, Douglas was replaced by Justice John Paul Stevens. Okay, so, you know, as the Bible says, there's nothing new under the sun. You know, majorities did come out in favor of things Justice Brennan championed in the 1970s, such as reproductive rights, okay? And, of course, still the issues which never leave, civil rights and racial discrimination, okay? So a key Brennan case in the early 70s was Eisenstadt versus Baird, which, you know, struck down a Massachusetts law prohibiting contraceptives from being distributed to non-married couples, as well as Roe versus Wade in 1973, authored by Justice Blackmun, which Justice Brennan was certainly in the majority with him, which established the constitutional right to an abortion. This was a rare defection for the Nixon appointees with respect to a protection of an essential civil right, of the right to an abortion. That majority included Chief Justice Berger, Justices Douglas and Brennan, Justice Stewart, Justices Powell, you know, and Justice Marshall, of course, as well. 7-2 majority with Justices Rehnquist and White dissenting. Okay, so Brennan's influence continued to decline under the Berger court, but even this was not as bad as it would be later on in the 1980s under, you know, the addition of more conservative justices Sandra Day O'Connor and Antonin Scalia. All right, in the early to mid 1980s, when, you know, his influence would decrease even more, and quite often at this point, you know, even though his liberal majority now certainly included Justice Marshall, but also included Justices Harry Blackmun and John Paul Stevens in certain cases, and hopefully Lewis Powell, depending on the issue. You know, these became harder for Brennan to defend the causes he championed, civil rights, civil liberties. During the 1970s, you know, he established the firm opposition to capital punishment that would come to characterize his jurisprudence. And, you know, he viewed it to be unconstitutional in all circumstances, as prohibited by the Eighth Amendment's ban on cruel and unusual punishment. During his time on the court, only Justice Thurgood Marshall agreed with him in full with this position. Okay? So these two were united and unwavering in their opposition to capital punishment. All right? And no other justices agreed with them, but they were able to occasionally get other justices to go along with certain aspects of capital punishment, not the punishment per se being unconstitutional. All right. So with the end of the Berger court in 1986 and the beginning of the Rehnquist court in 1986, all right, which lasted until his retirement in 1990, service under the Rehnquist court, 1986 to 1990, Justice Brennan's influence further declined. So, you know, you have a conservative majority now, headed by Chief Justice William Rehnquist, with the addition of Justices Sandra Day O'Connor, Antonin Scalia, you know, later Anthony Kennedy, Byron White, all right, and you know, these individuals, you know, provided, and depending on the issue, again, Lewis Powell, he was the key swing vote here. With Powell's retirement in 1987, he would be replaced by Anthony Kennedy, all right, which left the liberal bloc pretty much only with Brennan, Marshall, Blackmun, and Stevens, all right, and these four were often in very passionate dissent by this point. You know, it was not good for the cause of liberalism, and it caused them to be often very bitter in their dissents, as they viewed the majority led by Rehnquist quite often as eroding the civil liberties and civil rights, okay, that, you know, the court had been protecting for a substantial amount of time up to that point, okay? So, you know, with the end of the 1980s, you know, we see two very powerful Brennan opinions. First in Texas versus Johnson in 1989 and U.S. versus Eichmann in 1990, where the court ruled that the protection that the burning of the American flag was constitutionally protected as speech under the First Amendment. Okay, you know, Justice Brennan was the author of these opinions for a reason, not only because he was in the majority, but because he could put it in terms so clear and so pristine that, at least in his mind, you know, even detractors couldn't disagree, although that wasn't the case. You know, these are two of the most hotly disputed and chastised court opinions in history. First case, Texas versus Johnson, dealt with a state law prohibiting flag burning. U.S. versus Eichmann dealt with a federal law prohibiting the practice. Okay, so these were very unpopular opinions with the American public. All right, Justice Brennan put it in terms that is hard to disagree with, but certainly compelling. That to prosecute the burning of the American flag dilutes the freedom that this cherished emblem represents. And me personally, I hate flag burning and hate, you know, to see the flag treated in such a way. I've always felt that if you think, well, obviously, country does need reform, but if you want to reform the country, wash the flag, okay? You want to display it, wash the flag, wash it of its impurities. Don't burn it. You know, it's very disrespectful and very unnecessary, all right? So, you know, in 1990, this is when we see the end of Brennan's time on the court and his, you know, ardent defending of his liberal causes, civil rights, civil liberties, you know, protection of criminal defendants, you know, which was the highlight of the Warren Court. In the 1970s, you know, his highlight of his jurisprudence was the protection of protection of gender rights, protection of women against gender discrimination, rather. All right. You know, in the 1980s, you know, he renewed the protection of civil rights claimants, you know, and, you know, these were all, again, as the Bible says, nothing new under the sun. All of these issues Brennan was constantly defending throughout his 34 years on the Supreme Court. Though the times changed, the issues didn't. All right. You know, like I said, in the 60s, criminal defendants' rights and civil rights. In the 70s, women's equality. In the 80s, opposition to capital punishment and more protection of civil rights, you know, with a Republican president and increasingly conservative additions to the Supreme Court. All right. So in 1990, Justice Brennan suffered a stroke. While, you know, it did not reduce him to a point of invalidity, return him to an invalid, so to speak. But it certainly weakened him to the point where he felt it was in his best interest to leave the court. All right. And that is what he did in July of 1990. Okay. Bringing an end to an era of passionate defense of civil rights and civil liberties by Justice William J. Brennan Jr. All right. With his retirement in 1990, Justice William J. Brennan Jr. would be succeeded by First Circuit U.S. Court of Appeals Judge David Souter, who retired himself from the court in 2009. Okay, so that's covering Justice Brennan's period on the Supreme Court, 1956 through 1990. And of course, some of his most famous opinions, like I said, were Roth versus U.S., 1957, Cooper versus Aaron, 1958, Baker versus Carr, 1962, Malloy versus Hogan, 1964, New York Times versus Sullivan, 1964, Jacob Ellis versus Ohio, 1964, Goldberg versus Kelly, 1970. Okay, and you know, these are the opinions Brennan is most known for, as well as Texas versus Johnson, 1989, and U.S. versus Eichmann in 1990. All right. Chief Justice, just want to mention, Chief Justice Warren Burger had the, you know, a general, somewhat of a dislike for Justice Brennan, and during his early years on the court, certainly did not give him anything landmark, all right, but rather assigned him opinions that would have fairly minimal impact. You know, Chief Justice Burger was not exactly fond of Justice Brennan, all right. The feeling was somewhat mutual, but Brennan was more open-minded than Burger, all right. So that takes us to the justice's personal views. Now, interestingly enough, Justice Brennan's personal views differed quite greatly from his constitutional perspectives. With respect to capital punishment, although he had spent, his entire time on the court as opposed to it and viewing it as against the Eighth Amendment, personally, he had no issue with it. None whatsoever. Ironic indeed. But yes, in one instance, he, read what had happened, facts of a case, and said plainly that the bastard ought to hang. Obviously, he certainly did not oppose it on a personal level, but throughout his time on the court, opposed it on the constitutional level. All right. With respect to abortion, all right, Justice Brennan was a passionate defender of reproductive rights while on the court. Okay. But personally, he abhorred abortion and would never support the practice. All right. With respect to obscenity and pornography, the very first issue that defined Brennan's first issue that defined Brennan's jurisprudence, rather, on the court, he personally was disgusted by it, but gave it a substantial amount of protection during his time as a justice. With respect to the press and freedom of the press and, free speech, Brennan hated the press, and certainly personally felt that certain forms of speech probably should be restricted, such as flag burning. He hated both of those things, but gave them, almost unfettered constitutional protection. And New York Times Co. versus Sullivan in 1964, which struck down most states' libel laws at the time, giving the press an unprecedented amount of freedom. All right. And with flag burning, like I say, he hated it, but Texas v. Johnson, U.S. versus Eichmann, Justice Brennan, gave flag burning judicial blessing as protected speech under the First Amendment. So, his personal views quite often conflicted with his constitutional views. In his personal life, Justice Brennan was an average guy. He was never rich, always a middle-class man of modest means and a very humble fellow. He dealt with the same things most of us have dealt with at some point, financial problems that plagued him, during much of his time on the court, okay, especially after he stopped teaching and sold all of his investments, and stopped doing public engagements, for fees. That really hurt him. The only thing that saved him was increase in the associate justices' salaries. He dealt with cancer on a personal level. He had it briefly in the 1970s. His wife had it as well. Okay. She was able to beat it, but ultimately, or if she didn't beat it, I know she suffered with it. I forget exactly, but I know she suffered with it for a little while, ultimately before her passing in 1982. I think she dealt with it as best as could be expected at the time. His wife also suffered from alcoholism, and at least one of his sons, Justice Brennan, had 3 children, Hugh, William III, and Nancy, all right? And at least one of his sons suffered from alcoholism as well. So, he had to pay college bills, he had to pay tuition, the justice had to deal with the same things the average person has to deal with or has dealt with in their past, So, it's and his inability to control and keep a lot of these things, in the pot certainly contributed to his empathy toward others in similar situations. And that's, whereas it could have made him bitter and hostile toward other people, it only increased his empathy. Okay. And, while Justice Brennan was, a powerful advocate for equal rights for women, interestingly enough, he really had to be persuaded to hire a female law clerk, something he didn't do till the late 1970s, when a former clerk who was a male told him, Mr. Justice, you're a hypocrite and you could possibly be sued under the very precedents that you've created here. And only then did he relent. And, but his, didn't really hire many thereafter, but he did get a few in there. And he did not hire his first African-American law clerk until 1990. But due to his retirement, the two were never able to work together. Justice Brennan was a classic individual of his time, especially with respect to women, though I don't quite know why he never hired an African-American law clerk, especially given his close relationship with Thurgood Marshall and other African-Americans had clerked at the court, certainly during his time there for other justices, especially Thurgood Marshall and Chief Justice Warren, but he never hired any during his previous, time on the court. So who knows? But I'm not going to hold that against Justice Brennan. Like I said, he's always been one of my most preeminent role models in the law, and his jurisprudence protecting civil rights, for African Americans and women, is beyond question. Okay, so no one is perfect. Okay, that once we get that out of our minds, that people have to be perfect, we tend to look at them in a different light. People are people. Humans are humans. Everyone has their predispositions and biases, all right? Still good people at times, even if they don't conform to rigid standards we've established, okay? So that is my lecture on former U.S. Supreme Court Justice William J. Brennan Jr. He passed away on July 24th, 1997, at the age of 91, okay? And the Brennan Center for Justice stands as a tall tribute to the legacy of this powerful man. So if you have any questions or controversies, you can leave them down below and I'll be happy to answer them, okay? Before I go, I highly recommend this book, Justice Brennan, Liberal Champion, by Seth Stern and Stephen Wermile, all right? Excellent book. Anything you'd ever want to know about Justice Brennan is in this book. All right. Additionally, The Brethren by Bob Woodward and Scott Armstrong gives you a great deal of personal insight about Justice Brennan, and the relationship that he had with his clerks and other justices. Deep stuff. Very controversial book when it came out. All right. So I thank you so much for listening to my lecture. If you enjoyed it and gained a thing or two from it, drop me a like. I'd appreciate that. If you've not subscribed to my YouTube channel, I'd appreciate it if you did that now. Your support is so, wonderfully appreciated. I can't even say it in words, right? And, hopefully you continue to listen to my videos and lectures and expand your mind about the Supreme Court and about a whole host of other issues. Okay, thanks again for listening. All right, I appreciate it. Take care. Stay safe out there. And I'll talk to you at the next lecture or bite. Peace.